You're on the clock.
I just want to respond briefly to what counsel said about the Roberts case. If Your Honor reads the Roberts case, they did ask initially in the questionnaire about litigation, but one thing that was very important to the court was that Roberts' attorney during voir dire clearly clarified this inquiry, and he said, has there been any kind of lawsuit, divorce, collection of a debt, breach of contract, assault and battery, auto accident, defective product, medical negligence, divorce, domestic assault? And that's pretty clear. So that's why the Roberts case said it was clear in the Roberts case. It wasn't because of the questionnaire that said, have you ever been involved in a lawsuit? And if Your Honor reads this case, I think you'll see that the court would have a very different opinion if it had just been the questionnaire itself. So I do agree with the De La Rosa 3 elements that the defense has to prove. I do not agree that they have met those burdens. These facts are not undisputed whatsoever. I think the only one that could be termed as undisputed is the first thing that the defense mentioned, that was the questionnaire where Juror 15 marked no when it said, have you ever been a victim of a crime? She testified that she answered no because she misunderstood. However, I do agree that that does not make a difference when you're looking at the case law. But nonetheless, she did raise her paddle, Judge, later on when the defense asked, has anyone experienced an abusive male? She raised her paddle. She testified that she raised her paddle, or it's in her letter that she gave to the court. Also, in Mr. O'Keefe's affidavit, Exhibit A, where it says, experience abusive male, and it has the number 15 written down. She raised her paddle. So even if she said on her questionnaire she was not a victim of a crime, she did raise her paddle when she said, I've experienced an abusive male. So I don't think that it's clear that this was not rectified and remedied with that question. But however, even if the court believes that it was not rectified, the defense never followed up with any of these questions when they asked, has anyone ever experienced an abusive male? The defense never asked Juror 15 any questions about this abusive male, never exercised due diligence, which is the third prong of the De La Rosa test. And also, Judge, and maybe most importantly, is that this issue, being a victim of a crime, is not material or relevant to the jury service of Juror 15. That even if she withheld this info, that she was the victim, and that's all we're talking about here, the victim of domestic violence, wouldn't that make her more sympathetic to Ashley Benefield, who is claiming she was the victim of domestic violence? So to insinuate the opposite, I think, would be disingenuous. I think it would align her more with the defendant than it would Doug Benefield. And perhaps most importantly is this issue could not have been that material because another juror, according to Mr. O'Keefe's affidavit, raised their paddle when they were asked, have you ever experienced an abusive male? Number 35 raised her paddle, and she was seated on the jury. She was never struck, and she was never asked any questions about the abusive male. So it's hard for the defense to try and say that this is material when they did not treat Juror 35 any differently than they did Juror 15. So the state's argument is that they have not met their burden, the De La Rosa factors on the first issue. The second issue is, have you ever been involved in domestic violence courts? First of all, Judge, the term domestic violence courts is very vague. I don't even know that I know what a domestic violence court is. Is that criminal? Is that civil? Is this an injunction? Is this a divorce decree? What exactly is this? And I think it was incumbent upon the attorneys to establish that and to flesh that out. And if you took the defense's transcript, or you were here, they did not delve into that, domestic violence courts, and did not expound any on what exactly is a domestic violence court. Just because there's an injunction doesn't mean that anyone ever went to court, or that anyone ever argued it, or that a decision was ever made. So as to whether the information was concealed, This information was never concealed because these items were, the injunctions, which is what we're specifically talking about, were dismissed. They were not litigated. There was no follow-up questions by the defense, so there was no due diligence. And then I would argue again that they're not material or relevant to this juror's jury service, and it would be the same argument as the previous issue. As to the last issue, have you ever had a child custody dispute? That was something that I asked. Juror 15 testified that she does not recall whether she raised her paddle or not. So I don't know that we can say that she didn't raise her paddle, but she said she did not recall. She did say that she did not see these issues with injunction as child custody dispute. She said to Your Honor that nobody filed for any motion to amend child custody, or nobody went to court for a divorce court or family court to amend the custody agreement. And Judge, if you notice from the transcript, the state never defined what child custody dispute meant. I never went into what exactly that meant. I never asked them specifically. I just asked child custody. There is a real possibility that these allegations were not even termed as disputes. Just because someone makes an allegation doesn't mean that there's this contentious dispute. It's just someone's making a wild allegation. The wild allegation is dismissed. So she did not withhold the information because, technically speaking, there were no child custody disputes. There were no motions to amend child custody. And again, the defense did not follow up with the questions because the defense did do questions after the state's questions. They did not expound or clarify any of the issues related to child custody. So for these reasons, I would say that the defense has not met their burden under De La Rosa, and I would ask you to deny.
Thank you.